Hello and welcome once again to India on the Brink Summit. I'm the Executive Director of Sticking the London Story, and together with Genocide Watch, the Alliance Against Genocide, and several other diaspora-led organizations and allies, we are organizing a 3-day summit to commemorate 20 years since the Gujarat genocide and make a critical assessment of where India is headed as a nation. Through this summit, we are engaging with global experts, thought leaders, policymakers, and implementers to learn how we can defend democratic values and strengthen our commitment to human rights. We are painfully aware that in the world today, fascism is on the rise. We are witnessing an unprecedented attack on universal human rights and on our commitment to democracy, human dignity, and human life. There is hardly any continent in the world today which is not witnessing grave violations of human rights, crime against humanity, genocide, or war. And therefore, today, we bring to you this panel to learn from international lawyers and experts on what is our collective responsibility as nations, as communities, as non-state actors, and perhaps also as individuals to rise up in solidarity with the victims of human rights abuse. I'm joined here with 3 eminent experts. I will first invite Irina Victoria Massimo for her remarks. Irina is an international human rights lawyer, activist, and professor. She has served as rapporteur of the High Criminal Court of Buenos Aires province in Argentina, where she focused on institutional violence, police brutality, and gender-based violence cases, many of which became guiding jurisprudence. She has served in international investigative delegations, trial observations, missions, and consultancy projects related to human rights and international crime. She has taught courses and workshops on international human rights law, penology, criminology, and international criminal law at the national and international universities and institutions. She's also founder of the Lemkin Institute of Genocide Prevention. Welcome, Irene. The floor is yours.
Thank you very much, Ritu, for your generous presentation. Thank you also for this invitation. Especially, I'd like to thank Gregory Stanton, Dr. Stanton, for thinking of me to participate in this important conference. And also, I would like to greet my fellow panelists here, Catherine and Tunkin. It's a pleasure to be sharing this panel with you. And well, yesterday, Ritu, when you asked me for a pre-press release, I sent you a line that I like to always think of the use of the law as a lawyer. Sometimes in situations of conflict, one feels a bit useful because it's usually doctors or I don't know, nurses that are extremely needed. But the law is important. And I sent you this quote that, I mean, it's inspired by others, of course, but it's my own quote, as the law is an essential tool for the construction of peace, and for that purpose it must be used. Otherwise, we are destined to fail as a society and to live in a permanent state of violence. And thus I like to think of that importance of law, and in that context also of international law. And I like to highlight in this 5-7 minutes that I have, and then I love to engage in further discussion on this, but I like to highlight 2 important purposes of international law in particular. And one is for accountability, of course, and the use of accountability can bring long-term preventative measures for further crimes and also for human rights violations. And also the international law not only as accountability and prevention in the long term, but also in the very short term to prevent further crimes by the use of different tools within national and international justice systems. And I'd like to put a couple of examples on this. I always like to think that there are many possibilities for accountability, responsibility, and for prevention within this. And I always mention the possibility of national tribunals. A great example of that is Argentina, Chile, and Guatemala, for example, which went through different periods of the dictatorships, Guatemala for a much longer period of time, but Argentina around the 1970s, 1976 to 1993, Argentina in particular, and Chile after, almost up to the 1990s with the peace accords. All three countries have carried out national trials and are a great example of how those particular trials form a language of human rights, an understanding of human rights, and also the idea of preventing human rights violations and international crimes in the future. I always like to put the example of Argentina, which is, of course, the one I know the most, as I am from this country, from Argentina. Since before the 1970s, there was one understanding and a very short knowledge or very limited knowledge of society of what human rights were. And after a long struggle for accountability, memory, and truth, the what we call justice, memory, and truth in Argentina, there is a general knowledge of human rights language, which of course prevents current possibilities of human rights violations. With this, I'm not saying that Argentina doesn't commit internal human rights violations, of course, but it has been certainly a tool that has helped society understand the importance of respecting human rights, protecting human rights, and repairing in case of human rights violation. Argentina in particular carried two sets of trials. In 1983, right after the end of the dictatorship, a truth commission was established. It was the CONADEP, Commission for the Disappeared, of the National Commission for the Disappeared, Comisión Nacional para la Desaparición de Personas, which gathered much information and much evidence that would be later used and continues to be used in the national trials that we have. And Ritu, you can feel free to ask me further information about this, because it might be interest for the particular case of India. And in a trial to the juntas, or to the military juntas, was established right after. It's one of the first, or one of the cases where the least amount of time happened between the ending of the dictatorship and the establishment of a national process of justice, where the heads of the military juntas and at that time also the heads of the guerrilla organizations were tried in 1985. Of course, after many cases of internal conflict, gross human rights violations that account for international crimes, there is always a period of impunity, and there's a struggle against that impunity. In this context, international non-governmental organizations, the use of universal jurisdiction came into place as well, because trials were open in different parts of Europe, etc., until finally we got a new process of justice in 2005, around 2006, that is still going on in Argentina after so many years. So this has helped us to understand the importance of justice, of accountability, of this language or common language of human rights and of preventing human rights violations, and thus it helps us to prevent future human rights violations. And on the other hand, I mentioned the importance of accountability, of immediate accountability, in order to prevent I would say deeper human rights violations in many cases where there is a conflict going on. For example, like the case of the Rohingya that started long before 2017, but I'm just going to focus quickly on 2017 on, because it's where the biggest influx of Rohingyas came. Very quickly, many organizations started gathering evidence. Very quickly, of course, it was universal jurisdiction started to be open in Argentina at the end of 2019. Also, a case brought under the ICJ, etc. This could prevent further violations of current violations against the Rohingya, because the Rohingya are put in the map. There's the Rohingya are being known by the global society, but also by different countries. In the particular case of Argentina, for example, there was not much knowledge about the Rohingya community, of course, because of distance and cultural differences, but this also helps in that. Another case that I want to highlight quickly is the case of Armenians, for example, in Nagorno-Karabakh, which brought a case under the ICJ via the Convention Against All Forms of Discrimination. So this could prevent further, for example, culture and destruction and the commitment of different human rights violations and international crimes of Armenians located in Nagorno-Karabakh at the moment. So those are the different, very quickly, the different tools or the different ends that international law used nationally or also internationally can help for accountability or for preventing more immediate and future human rights violations and international crimes. So I think I'm good with time. And please, thank you, Ritu.
Thanks a lot, Irina, and I will come back to you with some of the points that you made in the speech, and we can discuss it later. But before doing that, I would like to introduce our audience to Catherine Southwick. Catherine is an international legal scholar and independent consultant with the U.S. Holocaust Memorial Museum on the role of domestic criminal justice system in atrocity prevention. I want to remind our viewers that U.S. Holocaust Memorial Museum is also the one which identified India as the second country at risk of genocide very recently. Catherine has previously worked for more than 15 years on human rights and legal reforms in Africa, Asia, and the Pacific Islands. She worked for the American Bar Association Rule of Law Initiative in Washington, D.C. and the Philippines on programs relating to judicial reform, anti-trafficking in person, and Asian human rights system. Catherine has worked in the Office of the Prosecutor at the International Criminal Tribunal for the former Yugoslavia and the State Department's Office of Legal Advisor. Catherine has also spent time in New Delhi, where her work focused on religious minorities and refugees in South Asia. Her commentary on human rights, statelessness, and Rohingya crisis has appeared in media and in scholarly outlets. So welcome, Catherine. The floor is yours. Please take your time for your intervention. Thank you.
Okay. Thank you very much, Ritu, for your kind introduction and to the summit's invitation for me to speak here. I also want to emphasize that I am speaking in my personal capacity and not on behalf of any organization. The question you sent for us to consider was, can international law prevent genocide of India's Muslims? And that would also include Rohingya, many of whom are Muslim. And my short answer to that question is yes, but there's a big caveat. International law can prevent genocide, but only if India and others are willing to implement and enforce international law. International laws have long existed to prevent and deter genocide and other mass atrocities, such as crimes against humanity and war crimes. But in practice, enforcing these laws is ad hoc and subject to the diverse interests or lack of interest on the part of states and other actors. The question then becomes not necessarily can international law prevent genocide, but rather can states, their citizens, and other actors see compelling interests in preventing genocide or other mass atrocities and muster the will to act. And once they do act, what are the mechanisms or tools through which they can go about effective prevention? I will talk briefly, spend one moment at the end here on the mustering the will to act, but I just want to answer your question, highlight some of the key laws and norms relevant to genocide prevention, including in the case of India. India, of course, has ratified the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, along with over 151 other states. Under that convention, states pledged to prevent and punish the crime of genocide. Under Article 3, direct and public incitement to commit genocide is also punishable. The states parties are also to enact necessary legislation to give effect to the convention. And any state party can call upon the UN to take action under the UN Charter to consider appropriate steps for prevention or to suppress acts of genocide. A state party can also bring another state to the ICJ, as Myanmar has in the case, as Gambia has in the case of Gambia versus Myanmar regarding the Rohingya. There's also the Rome Statute of the International Criminal Court, which is empowered to investigate and prosecute mass atrocities such as genocide, but India is not a state party to the Rome Statute. And so the ICC could only obtain jurisdiction over crimes committed within a non-signatory state if the UN Security Council refers the situation to the ICC prosecutor. And to be honest, that's unlikely to happen given the current makeup of the Security Council and the willingness of those members to veto those kinds of initiatives. So I've mentioned some of these judicial mechanisms, and excuse me, as well as Irina has talked about those. But I also want to speak about the less well-defined but no less important laws regarding prevention. The judicial mechanisms often come after crimes have been committed. They could theoretically come for cases of prevention, but in actual reality, they tend to come after the fact. And in some cases, some people feel they come a little too late. They can be slow, and the impact can vary. They are nonetheless very important for shaping discourses against mass atrocities and creating pressure on states. But returning to just sort of the prevention obligations, we have, of course, the obligation to prevent genocide under the Genocide Convention, and the responsibility to protect doctrine, which is not a formal treaty, but constitutes sort of a common understanding among UN member states, to step in when a state fails to protect or prevent mass atrocities against its own populations. But what that responsibility actually entails or demands from states in any particular case is difficult to define, in part because every case is different and there are no one-size-fits-all approaches. And of course, let's not forget the UN Charter, which affirms that the UN's purpose is to maintain peace and security and to cooperate in promoting respect for human rights without discrimination. The Security Council is empowered to act when it identifies any threat or breach of peace. And I also want to point out, when the Security Council fails to act, a majority of member states can invoke a Uniting for Peace resolution and hold an emergency special session to make recommendations. As I said, these laws of prevention are kind of ambiguous and open-ended, and as a result can lead to a sense of inaction. But so it is the acting on the prevention obligations that really gives shape and defines these obligations. And fortunately, the UN and other organizations have developed clear frameworks to evaluate risks of atrocities and sources of resilience, such as the UN Framework Analysis of Atrocity Crimes. And with these frameworks, we can therefore have the knowledge in terms of what we need to do to address atrocity risk. And that brings me to that little question I reframed, which is, can we see these compelling interests and muster the will to act? Once we have that awareness of how atrocity risk builds, and we're more empowered to pressure institutions to act on their prevention obligations, we can see what needs to be done, and we can ask the government of India and other governments, what are you doing to live up to your prevention obligation under the Genocide Convention? And then before that advocacy can happen, we need to feel convinced that we have a compelling interest. Of course, we want to avoid mass violence, but it also helps to understand what is deeply at stake and what the broader risks are when we're talking about atrocity risk. India is the world's largest democracy. If it goes down this dark path, then it does not bode well for democracy elsewhere. A democracy that does not protect minorities looks and acts less and less like a democracy. Attacks on minorities enable attacks on any and all political critics. And this is what happened in previous cases of mass atrocities. We see more abuses of power and human rights violations. Mass violence against Muslims will likely exacerbate tensions with nuclear neighbors and other countries with large Muslim populations, and past violence becomes a key risk factor for future violence. So with these stakes in mind, my hope is we collectively recognize our compelling interest in pressuring governments to make real the promise and obligation of prevention before it's too late. Thank you.
Thanks a lot, Catherine, for those remarks. And in fact, just this idea that India is the world's largest democracy, and we need to act to ensure that it stands to its democratic values, especially now, given the global context, where we are seeing yet one more madman in Moscow doing what he wants to do with the world. I will come again to these questions in the discussion round, but I first want to go to Tun Kane, and let me quickly introduce Tun Kane to our audience. Tun Kane was born and brought up in Arakan state in Myanmar and was rendered stateless by a 1982 nationality law that excluded the Rohingya from the list of groups considered indigenous and therefore eligible for Burmese nationality. Might I remind you, this is very similar to what we saw happening in India in 2019 with the NTCE, with the Citizenship Amendment Act. Tun Kane is the current president of Burmese Rohingya Organization UK, which has been a leading voice for Rohingya people around the world. Tun Kane has briefed officials on the continuing human rights violations committed against Rohingya population at the US Congress and State Department, British Parliament, European Union Parliament and Commission, European national parliaments, and at the UN forums. His writings on Rohingya issue have appeared in several international media, including Huffington Post, and he has also contributed as a speaker on Rohingya issues for the BBC, Sky, Al Jazeera, and many other outlets. So welcome, Tun Kane. The floor is yours.
Thank you. Thank you very much. A great honor to be here with my two friends, Catherine Southwick and Arena. And it is very good to meet both of you, and a great honor. And thanks to the organizers inviting me at this panel. This is very timely and important summit. And I would like to express my heartfelt thanks to Greg Sturton and others holding this event, very timely again. And as a Rohingya, let me first express my sincere solidarity and closeness to the Indian Muslim, as well as we Rohingya and Uyghurs in China have been the target of discrimination and racial and religious hatred for decades, of dehumanization, of deprivation of our fundamental rights, of human rights. If these elements are accompanied by other elements such as ghettoization or non-recognition as citizen, destruction of our homes, we know as well expressed in Dr. Sturton's 10 stages of genocide, that these are elements that lead to genocide. Having said that, I would like to take up the question of this panel: can international law prevent genocide of Indian Muslim? Well, I would answer this question first by asking another question. Has international law have been able to prevent genocide of Rohingya? And was international law able to prevent genocide in Rwanda or that in Srebrenica? No, but this answer would be incorrect and incomplete if left as it is. Clearly deserve a more thorough explanation. In fact, international law is applied by and addressed to states. And this is the crucial point to which I shall return in a moment. Like first, let me say briefly that there are two mechanisms for prevent crime of genocide at the international level. First one is Convention of Prohibition of Punishment crime of genocide, ratified, as you know, both Myanmar in 1956, India in 1959. China also ratified by later in 1983. Convention has 4 mechanisms to ensure compliance with the prohibition of genocide, which specify bodies that can accuse a state or its organs of committing this crime. They are courts of the state whose territory acts of genocide are committed, International Criminal Court, a state lodging an appeal, which is the competent organs of the UN, like a state by lodging an appeal to the with the International Court of Justice. With reference to the first point, the fact that the court state in which crime of genocide is committed can guarantee a fair trial turns out to be utmost utopian. In fact, since genocide is often carried out by the state authorities or with their consent, the work of the court is mostly insignificant, does not exist at all, as has obviously happened in Myanmar, as I expect to happen in India. Not a single court in Myanmar opposed what was happening against our community. Not a single person rallied in solidarity with us before the coup 2021 February. While we received solidarity and support after the coup, when everyone has started to understand the true nature of the junta, this is to say that when internal response cannot come from internal court, it is important that it comes from the people who must account for and oppose what is happening. The atrocities, discriminations, human rights violation in Myanmar, in India, in China have happened in total indifference of the rest of the population. That is why it is important, fundamental to receive support from citizens at the first warning sign, not only after the damage is done. Secondly, establishment of International Criminal Court has been a long time coming. 1993, the first ad hoc ICTY, ICT International Criminal Tribunal, the ICTY was set up to try crimes committed since 1991. And then 1994, ICTR was established, but even ICTR was set up when the bulk of massacre had already been carried out, when the genocide had already been carried out. And so this court was set up to condemn them, not to prevent. In 1998, International Criminal Court was set up, which provided and still provides for jurisdiction over crimes committed on the territory of the state party, perpetrated by a national of state party. So it has no universal scope unless UN Security Council intervenes. Genocide can be prevented when a state laws complain with the ICJ, International Court of Justice, just as Gambia versus Myanmar. However, ICJ does not have the power to pass sentence by coercive means, so it can only find fault and declare the state guilty. Recourse to the competent organs of United Nations, such as Security Council, is another way. It only intervenes in cases where an act of genocide may involve a threat to peace, a breach of treaty, or an aggression. Not forgetting such intervention require consent for all 5 permanent members. And this is the crucial point. But the fundamental problem is extent to which states and courts succeed in enforcing the international law. UNSC did nothing while massacres were taking place against our community, Rohingya, in Myanmar, against the Uyghurs in China, or against the Indian Muslim, because the Security Council is a political body where those 5 states sitting there can apply their veto if any economic and various interests. So in matters of international crimes and genocide, UNSC is probably not a body that gives certainly of intervention, at least not in the areas interest of those 5 permanent members. In conclusion, it is not, according to me, a problem of international law per se if genocide cannot be prevented, but it is the willingness of states to apply those norms that is the real problem. Also, tribunals and courts have crucial role to interpret that and apply rightly the law. There is therefore an urgent need for a greater and more solid commitment on the part of the international community in protecting what are called imperative norms or just cogent for the international law, which, if violated, constitute an offense to the entire international community. And so there is a real need for the international community to respond on time to the silently commission of genocide as if they had been offended. It is therefore on the other states and the international community that prevent genocide, including genocide of Muslim India and its state. There must be a change in mentality and more convinced commitment to stopping atrocities. It should not be enough to set up an ad hoc tribunal to prosecute criminals. It should be possible not to go there at all and to put human lives and their rights before any other interest. This needs also to keep up the credibility and the value of the treaties and convention. The rule of just cogence can be prevented from being trampled on when signals are given due weight, when sanctions are issued, when one intervenes in the name of people, but also in the name of protecting entire legal system of protection and support of civil society is also important in this. I stop here. Thank you.
Thanks a lot, Tunkin, for those remarks. And I want to, I know I already told you that I would like to have this discussion about certain areas of protection, but given the remarks that were there are some burning questions which I think also are there amongst the audience. And one of them is about the state impunity, because as Irena mentioned, Catherine mentioned, and also what Tunkin mentioned, that there is this certain degree of state impunity which is there to act. And it is also somehow in our interest that the states must act on the international law, because if they don't, then this ad hoc action on the international law is not going to leads to long-lasting changes. So I want to know from three of you, and I'll go to Arena first, on how you see this impunity and how do you see that we can perhaps break this impunity in some ways if we can. So please.
Thank you, Ritu. This is a very difficult question. On the 24th of February, with the Lenkin Institute, we issued a statement that's part of our work on Russia's aggressive war on Ukraine. And on that statement, which I welcome everybody to check it's on our website, we called on different actors of the international community to what they should do, Vladimir Putin, the Security Council, etc. And I think at the end of it, one of the underlying problems that I at least from a critical theory approach or a third world theory approach that I have is that the world has not yet committed itself to global decolonization and economic justice. And I think this is probably the underlying reason why countries do not respect international law. They do not respect the Charter of the United Nations, which has been valid, legitimate for decades now, and do not sign and ratify different treaties like India itself, different treaties to protect human rights of the national and of the refugees. So I think, and this is a little bit the perspective of my work, it doesn't happen from one day to the other. Certainly, that's why I said it's a very difficult question. I agree with Tunkin that there should be a lot of emphasis put in the grassroots, in the people. I think the people have somehow not only a right and a responsibility, but also power. Of course, when they are grossly persecuted and victims of genocide as the Rohingya, it's very difficult to think of how would one act. But it's a responsibility of us who are not facing those crimes or gross human rights violations to put a word through different means. And I think that discussion of continuing ideological colonization and economic injustice is going to keep these violations of international law happening. And that's why there's so much emphasis put in certain conflicts than others. There's more, as Tunkin mentioned, the Rohingya being completely abandoned when they were grossly persecuted in 2017. But even prior to that, nobody realized that they were not considered citizens, that they had special identity cards, etc. And no one was able to prevent the Rwandan genocide, etc. And I think that colonial mentality is embedded within the United Nations, and it's represented in the Security Council. So unfortunately, I think that's what we must target and build and work on for a proper participation of different countries of the world, and all of communities being properly represented in the international community, to start at least a change that it's, again, not from one day to the other, but that will take decades probably. And there are questions in the chat for me, but I can leave them, Ritu, for later. That's fine.
Yeah, I would like to come to that question again in the second round. So first I want to go to Catherine, because she also mentioned a lot about the ad hoc functioning of the international law and the countries not taking account. So Catherine, your views onto it, please.
Yeah, it's a really big and difficult question. What it really comes down to, I think, is picking up on what Tunkin said, is about mindset and civil society, particularly within the countries that are directly facing these challenges. We talk about international law and international community as something out there that's going to come in and change everything. And the reality is that the change happens inside the country. It happens with a change in government, change in policy, change in public expectations, change in what the public expects, the standards they set out. The genocide against the Rohingya was able to happen, as Tunkin said, because the larger population was somehow apathetic or convinced by the government's propaganda. So the first line of offense against impunity is the public within the country, within India, if we're talking about India. And it is incumbent on Indian citizens, as it was, and it is now in Burma, Myanmar, to recognize how the persecution of one minority will have ripple effects on the stability and the human rights and rule of law within the whole country. The more you can get ahead of this problem, the less damage, irreversible, almost, it's not necessary. I don't want to say it's irreversible, but the worse we allow mass atrocities and the risks to develop, the harder it is to get out of them. Burma has a very long path now because they've allowed this, the world, the situation has been enabled for decades. But there is a lot of hope as well, because the public has come to a different place in a direction that is seeking more accountability and is demanding higher standards from their governments. And it is up to international law and the community to enable and support those positive dynamics towards reducing risk and building resilience, which is sort of the good governance and social cohesion that you really need in order to be a bulwark against impunity.
Thanks a lot, Catherine. It indeed comes down to the idea of using the law. Law as a tool is available, but the question of whether we are able to use it or not, right? So Tunkin, I want to give the floor once again to you to perhaps also talk to us a little bit about the Rohingya genocide, and also maybe reflect a little bit on the position that Indian government has adopted towards the Rohingya Muslims who have taken shelter, because in some ways, Indian government also definitely does have some sort of international responsibility to protect people from who are in India, and specifically in light of the judgment which came out from the Supreme Court of India last year, where they allowed for the deportation of Rohingya refugees who were inside India back to Myanmar, which was at that point very much in crisis. So Tunkin, please.
Thank you. It's a good question. Let me go first. The Rohingya genocide, it's been going on for many decades. People realize in 2017, not realize, and also international medias and picked up, because 1 million people fled from Burma to Bangladesh in 2017, August, September, and October, and where thousands of Rohingya were killed by the Burmese military, and that's how this happened. So let me bring, we are a native people of Arkan state, and we belong to Burma. And after independence, we have rights like other nationalities of Burma. In Arkan state, we are second largest majority. Another Rakhine Buddhists, and we are Rohingya Muslims. And mostly on that time, Rohingya have ethnic rights. We are recognized as an ethnic group, and that time my grandfather was a member of parliament, and my mother's grandfather was the first judge in Northern Arkan, but I was not recognized as a citizen. So that's how I left from the country. I'm lucky one to be here to speak, but like me, thousands of Rohingya, they're not allowed to go to university. They didn't get citizenship, and their lives were destroyed. So military started up 1962 a propaganda. They are illegal immigrant. We need to strip off these citizens' ethnic rights. And then he did a King Dragon operation 1978. 275,000 Rohingya fled from Burma. And because of international pressure, some of Rohingya were repatriated back under UN, but not as a citizen of Burma. And then naming military dictator, he introduced a law, 1982 citizenship law. And that is the way how he's taken away our rights. And then he imposed restriction of movement, marriage, and restriction on education. I witnessed how, for example, let's say from London to Manchester, if we need to travel, we couldn't go in Burma, we need to get a pass, and it takes 2 to 3 days. And if we want to get married, we can't go to, we need to get a pass. I saw some of my friends, my elder brothers' friends, they were waiting for 2 to 3 years. And if you married without permission, you were sentenced to jail. That is what's happened. And my old land, my father's land, were my father's land confiscated by the military, and they kept non-Rohingyas, or ex-prisoners. They settle in our village, in our places. And then many people become an unbearable situation. That's how people been fleeing in 1991, 92, and many years. And what's happened is after 2010, international community focus gone to Burma moving forward to so-called democracy. So I say it's a so-called reform. And then that time Facebook were there, and under Facebook being spread up, so many hate speech, propaganda, and illegal immigrant, get them out, kill them all. We don't want to see these guys. These are different from our people. They kind of speak Burmese, and a lot of different ways, insult and humiliation in Facebook being already given the platform. That's why we filed a case, Facebook recently in US and UK, about 150 billion compensation that we are pushing for that. And the other thing is, we have seen that, governments, institutions, and police, military, NLD, and USDP, everyone is on, they are no solidarity, just anti-Rohingya campaign were everywhere. Nobody wants to see this Rohingya. And President himself on that time the only solution is keeping them in the camp and sending them to the third countries. That was former military dictator, pro-military government, USDP president Thein Sein mentioned it in June 2012. So in 2015, we were not allowed to go to compete, not allowed to be a member of parliament and right to vote. So all the rights been taken away. In 2015, the first time in our history, we were not allowed to vote and not allowed to be member of parliament. In 2016, we have seen that under some militants attack that Rohingya were killed, collective action, and under that issue, and the 2017, we have seen again 1 million people fled, which is mass killing. So initially, if you look at Rohingya genocide, they denied our identity and existence first, taken away our ethnic rights, and then they taken away our citizenship right, denying citizenship, and denying the right to have children, denying the right to have medical treatment, denying the right to have education, and denying the right to have our land, and then created popular violence by doing hate speech, which is a Facebook platform. They did that. In 2013, 12, 14, people are starting up using many people in Burma Facebook platform. And then 2016, 17, mass killings, it's happened. Thousands of Rohingya women were raped, and more than 400 villages were burned down, and 1 million people fled. That is how that is a genocide, intentionally destroying our community by Burmese military and the government. And that's why we have case in ICJ and ICC. That case is, for deportation case from about the people who were fled. And I filed on Burmese Rohingya organization, my organization, and I filed a case in Argentina, which is universal jurisdiction case. I visited to Argentina 2 times, and last December, I testified that universal jurisdiction is to focus on horrific crimes what military committed against Rohingya people. So we believe that this case will move ahead, and we are very happy, and thanks to the Argentinian judiciary, they're giving us this opportunity to do that. So we really hope justice, there will be justice for the Rohingya people. So these cases are going on. And I jump in on your question on India. Yes, India, you can see their own citizens are facing that. We our solidarity with them, Muslims in India. And of course, Rohingyas are Muslim. So that is one of the way India is trying to do. Unfortunately, we have not seen many Rohingya were arrested, and they just detained and not getting proper aid. This is going on for many years. I visited India for 2 times and raised with many people, but still now the situation is getting worse. We really have to do our best to protect these Rohingya people in India, also for everyone. I stop here.
Thanks a lot. Thanks a lot for those remarks, Tunkin. I have to say that as an Indian citizen, a lot of us basically feel ashamed that instead of giving the solidarity that the Rohingya Muslims need at this hour, India is rather going into an oppression or a repressive action against them. I want to come back to you, Irene, on 2 issues. One of them raised in the question on was there any actual educational legal awareness initiatives which were taken place which directly led to communities having this essence of right, or this semblance. And I think this is very similar to the question also raised by an anonymous attendee. And then I also want you to reflect a little bit about this universal jurisdiction which is available in Argentina, which can be utilized by communities which have no other recourse within their own national jurisprudence, please.
Sure. Thank you, Ritu. I hope my internet is okay. I was feeling that it was failing a little bit, so I hope it's fine. Yes, I think this is a very interesting question here posed by Smriti Nevatia. I hope I said it okay. It's very interesting because the language of human rights was started with the grassroots. It started with the famous mothers and grandmothers of Plaza de Mayo. That's why I put a lot of emphasis in the work of the grassroots. In a time where women did not have a huge space in society, there was much more gender inequality. Women started to protest publicly against the Argentine military and civic dictatorship, which ended up with a very high number of disappearances and a lot of crimes committed, included crimes against humanity, and by courts ruled during this last more than decade, also genocide against a political group. So there were many interpretations of what a national group was, etc. I don't want to get into that. It's a bit complex. So that's when this more global language of human rights started. And then it really came out of, I think, and this is a personal question that should probably be analyzed better than by a sociologist and not by myself, a lawyer, but I think both the Truth Commission and the first trial played a huge role in understanding that individuals and the collective have human rights and that the state has obligations. Argentina, unlike India, has ratified, I think, almost all human rights treaties. And of course, at that time, the Genocide Convention was also ratified in the 70s and during the time of the dictatorship, was already valid in Argentine territory. And for us, human rights treaties have constitutional hierarchy. This was introduced by a 1994 reform. So those are, along with the constitution, the fundamental laws of Argentina. So every other law, a civil code, a criminal code, etc., has to be in compliance with human rights principles, standards, and human rights laws in general. In education, as a tool to sort of spread this language of human rights, was introduced in schools, actually. But after the starting of this second set of trials that Argentina started in 2005, 2006, because in the middle there was a period of impunity and amnesty for perpetrators. So I very much understand the struggle of the Rohingya in Myanmar and the struggle of Muslims in India and minorities or different groups persecuted worldwide, because you do not have support of your own state. And this is what happened in Argentina in the 70s and the 80s. The people did not have support. Those persecuted by the state couldn't find justice. Later on, and even in the aftermath, there was impunity, like I said, through amnesty and through the impunity laws that banned the continuation of the trials. Fortunately, with different political changes, we were able to continue with these trials or to restart trials, where not only the heads of the military juntas were tried, but also different hierarchical members of military, aviation, and navy, and also members, CEOs or chiefs of companies as well. Because we understood through time that it was not just a military dictatorship, but also there was complicity of the economic powers in Argentina that supported and maybe aided and abetting in legal terms of the ICC. I was thinking of that, were complicit with the crimes committed directly by the military. So I think that global language of human rights takes time for a nation. It takes different aspects. It takes public policy. It takes a change of laws. It takes, of course, judicial accountability. And it does in a very important way takes the role of civil society organizations to work around human rights and the need for the state to respect human rights. I don't know if I'm missing any part of the question, but I think sort of that was, I think that was my answer. We can go back a little bit if needed.
Thanks a lot, Irene. I want either Irene or Catherine to also take up this question about the universal jurisdiction and what kind of universal jurisdiction is available.
Sorry.
And please, that will be the last question for this.
Yes, sorry, I completely forgot. Catherine, you can start if you want. I just give the example that in Argentina, we have absolute universal jurisdiction. There has to be no link of a victim or anything to the Argentine territory. Some other countries, Argentina Argentina civil society in the 80s opened, actually in the 90s, open universal jurisdiction in other countries, but there was not absolute. Countries like Spain, France, or Italy sometimes require that there is a specific link to a victim. That was, for example, the French nuns, the famous case of the French nuns in Argentina who were killed by the military. Then there was a case open in France, in the case of Operación Condor, where there were Italian victims. But countries like Germany, Sweden also open universal jurisdiction, which is a principle. We have it in our constitution. Article 118 includes the concept of universal jurisdiction and actually the obligation of Argentina to open its courts to investigate crimes and punish perpetrators for the protection of human rights, of course, and accountability for international crimes or human rights violations. And I'm not familiar with all of the requirements of Germany and Sweden. Maybe Catherine can explain a little bit more. Maybe not. I don't want to put you on the spot, Catherine, but it depends on the different countries' requirements. For example, in the case of the Rohingya, the decision of the first instance was to reject, and then the appellate chamber decided to overturn that and found that Argentina has jurisdiction and has the obligation to open universal jurisdiction.
Thanks a lot, Irena. Catherine, do you want to intervene on national?
I'll just add sort of more broadly though with universal jurisdiction, and I know there was a question as well in the chat here about, you know, if you feel like you're in India and you don't feel like you have a capacity to act, what can we do internationally? What can the diaspora do? And, you know, it's these international processes, either the sort of political processes at the UN or the judicial processes through universal jurisdiction or, you know, the ICJ or even ICC, you don't, they're not necessarily ends in themselves. These institutions and these standards can be invoked and talked about and raised increasingly by people inside and outside of India, just to put the government and others who are enablers on notice that you are potentially in breach of serious international laws. And this is going to bring some really unpleasant attention to the country and to the government. And this is going to, and these kinds of laws and standards are out there in part to help provide, to announce a standard of behavior, and to also, they can impose consequences beyond sort of the legal consequences that the processes can lead to, sometimes don't lead to. But even if they don't lead to those consequences, they bring a kind of pressure to the governments that it's hard to define. It's hard. I mean, there was another question. It's very hard to prove a negative. It's hard to prove that you prevented something, but you can really watch carefully. Maybe when the news comes out that that I don't know, the ICC prosecutor is looking at this, or if there are refugees now pouring over a border of a state that is actually a party to the Rome Statute, the ICC prosecutor might take notice, as it did in the case of the Rohingya, looking at crimes with consequences in Bangladesh, who is a state party to the Rome Statute. So all of this is to say that this can be a very valuable, the international laws and standards can be very valuable in simply raising the profile of the challenge here and putting the governments and persons on notice of what that they could be in breach. And this again has implications for international investment, foreign major deals can get slowed down. And so it's important to recognize those other potential uses of these laws.
Thank you, Catherine. I'm being mindful of the time over here, and I would like to end this panel over this note. And I just want to say to our audience that what Catherine said, what Irene said, and what Tunkin said, I just want to reiterate and underscore that there is international law, there is human rights law. The need is that we use it as a tool for protection of the people that we are so passionately talking about over here. And with this, I thank my panelists for being here today with me and for the kind discussions. And I also want to make an announcement, sorry, that in I think 15 more minutes, we are going to start with our next session, which is on the role of gender in prevention of genocide. We again have international lawyers in that session who have been working on the ground with different communities from Bosnia and elsewhere on not just preventive measure, but also reconciliation measures. So please join us there, and thanks a lot. Thank you, everyone.
Thank you.
Thank you. Thank you very much.